Our next speaker is Ms. Padmaja Chinta, partner at Dunnington, Bartholow and Miller. She will share her expertise on monetizing and protecting IP in cross-border deals, an area that's becoming increasingly vital in global business operations. Please join me in welcoming Ms. Chinta.
Okay, well, I think I can still say good morning. We're before noon. So good morning, everyone. I'm delighted to be here. Thank you to the Indian Consulate for hosting this wonderful conference. Coming right after the coffee break, so hopefully you're all caffeinated and, ready to dive into the fascinating world of intellectual property in cross-border deals. Now, I may not have the cool Sherlock Holmes type images that some of the earlier panelists had, but I'll do my best to keep this engaging as we talk about monetizing and protecting IP. Okay. Sorry. Okay, there's a delay. Okay. Okay, sorry about that. So let's, I want to start off with some basics, right? What are we talking about? Why does it matter? Before we get into how we go about it. So when I say IP or intellectual property, what am I referring to? Basically every kind of IP. It could be patents, trademarks, trade secrets, domain names, know-how, and the like. And for this purpose, it doesn't really matter who developed this IP. Maybe you developed it by yourself or jointly with another partner, or it's the IP of a third party that you're simply licensing. And of course, not every IP is at play in every deal. Now, for example, if we're talking about pharmaceutical deals, patents play a big role. If we're talking about consumer products, branding and trademarks are important. Or we're talking about food industry or medical testing space, trademarks and know-how becomes important. So when you're making deals, why should you care about IP? Well, frankly, because they are what I call your crown jewels that drive the deals that are connecting different countries, right? The US having its cutting-edge technology, connecting with the Indian market that has the scaling, the talent, and as we saw, tremendous growth opportunities. Or it could be the other way around. You have innovation of an Indian company looking to get market access in the US. Now, leaving aside the fact that every, there are rules and regulations between the two countries that will affect the IP, think of IP as the key to the vault that unlocks the deal. Almost every deal question is flowing from it and depends on it, whether we're talking about valuation, market exclusivity, or even investor confidence, right? So in fact, almost the vast majority of deals, IP is the reason for the delays in closing the deal and often for derailing the deal. So how do you go about protecting an asset that is as valuable as this? The first step is, of course, identify what IP do you have? Do you have patents? Do you have trademarks? Do you have trade secrets, right? Then secure written assignments. Before that, you then confirm who actually owns it. You've identified what IP you have, then you figure out who actually owns it. Is it the company? Is it the founder? Is it a consultant who developed it? Or a joint partner? Then you make sure you secure written agreements from whether it's inventors, employees, independent contractors, to make sure that the rights are actually vesting in your business entity. And remember, IP rights are territorial. So your Indian patent is no good here in the US, and your US patent is not going to protect you in India. So you want to make sure when you're filing patent and trademark applications, you file in the country where you're intending to operate and be at play. And of course, file as early as possible, because delaying can mean losing your rights. Now, when it comes to trade secrets, don't disclose everything at the same time, right? Release information in stages, right? Initial stage, when you're just getting to know the other side, use NDA and just disclose the non-sensitive product specifications, for example. Then once the relationship deepens, maybe go to the next stage and disclose limited technical details that are necessary to do the evaluation. And then don't disclose your full source code and your algorithms until the deal is actually signed. Right? So just give enough information at each stage to move the deal forward. Of course, use NDAs. Have them in place, make sure they're customized for your situation and not like a generic NDA. And importantly, make sure your contracts, we talked, the previous panelists talked about contracts and agreements. Make sure they're clear, right? Especially the sections or the provisions dealing with ownership, with licensing terms or use rights, should never be ambiguous. Now that we understand a little bit about how we protect the IP, let's discuss how can you actually create value from it, right? So this is where there are different ways to monetize your IP. The licensing and tech transfer agreements are often the easiest way to do this. They let you enter into new markets without the full risk or costs of full-scale operations. So, and you can design flexible revenue models. It could be running royalties, it could be upfront payments, or it could be payments linked to milestones related to sales targets. But be aware that there are regulatory restrictions. Right? Both the US as well as India may have certain controls on the transfer of certain technologies, especially if you're dealing with, in the space of defense or biotech or even semiconductors, right? So always check, the US export control laws, the India, the FDI rules, to make sure, before you finalize the deal. Another way to monetize your IP is using joint ventures and strategic partnerships. So they will let you turn your IP into revenue by combining your technology with a partner's, say, manufacturing capability or access to market in a different territory. It also helps you, of course, share the R&D costs and speed up localization in new markets. For example, an American company, might provide the technology, a patented technology, but the Indian company can modify the design to suit and adapt to the local markets. The key here is to define the ownership of future IP. When you're doing a joint partnership, you have to know who is going to own IP that comes out of that partnership, right? How are the improvements going to be used? And make sure to include exit and buyout triggers, right? So that you maintain flexibility. And always record what each side is bringing into the deal. Whether it's patents, whether it's know-how, whether it's distribution network, so that way you know the value of your contribution to the partnership. One other way to monetize your IP is using IP-backed financing. So it basically lets you unlock liquidity from your dormant IP portfolios. These are the patents that are hanging on your clothes hanger, a way to turn them into money and generate working capital without giving up equity or selling your company outright. So basically, you convert your IP into cash by using it as a collateral, just like you would use real estate as collateral to get a mortgage, right? Or you can securitize your royalty streams from the IP. What does that mean? That means the investor is going to give you cash now in exchange to receive future royalty payments. Of course, these have to be predictable royalty payments, so that is something to keep in mind. Now, lenders usually have strict requirements, so you want to combine your financing with insurance and escrow provisions to make sure you can secure repayment of the loan. Another way also to monetize is franchising. This helps you leverage your brand equity. And this is how, branding and your trademarks can be turned into revenue. You will have a local partner manage the sub-franchise while you keep the central control. And here it's important to have good provisions in the agreement on quality control, because you want to make sure you are controlling the reputation and quality of your brand. So now that we have some understanding of how to protect the IP or how you can monetize it, what should you be thinking about when you are doing a deal and you are the investor in the cross-border deal? So the first thing is you want to confirm that there is clear ownership of the IP, right? Investors should make sure that all the IP rights are properly documented and assigned to the target company before, whether the assignments are coming from, as we said before, employees or independent contractors or someone else. You want to make sure the IP resides in the target before you invest in it. And check the ownership at the entity level. A lot of times there will be subsidiaries and affiliates, holding companies. So you want to make sure the chain of title is good and, check your inventorship. Did the inventor really, invent this? Do a scan for open source things to uncover any unrecorded IPs, hidden liabilities. And remember, because IP is territorial, you want to make sure as an investor that you have full territorial coverage. Are the patents or the trademarks filed in both countries? Are both countries going to be at play? You want to make sure you have coverage where you're going to be in play. Undertake freedom to operate analysis or the FTO analysis to make sure that you're not stepping on the rights of someone else's IP. Right? This is where you will uncover blocking patents or pending applications or pending litigations that can throw a curveball in your operations after the deal is done. Then do your regulatory and compliance review. Check the rules on data transfer, export control rules to avoid legal issues later on. The next, and this one is really important, right? You want to make sure as an investor, you are getting the protections that you need from your agreements, right? The licensing terms relating to royalties, market exclusivity, they should be very clearly defined, right? Get a representation and warranty on the target actually owns the IP that it says it owns, that it is not infringing on someone else's IP. So don't take their word for it, get a rep and warranty. And have holdbacks and escrows linked to milestones, so to protect against, post-closing issues. And don't forget to include IP indemnities and insurance to figure out and have protection against potential claims that could be made in future. And as an investor, you also want to have the ability to audit and step in rights, right? So make sure you carve that in the agreement, because you want to verify the IP use of the IP, you want to, enforce your rights if necessary. Have a proper exit and enforcement strategy, right? So think about how you want to get out, how you can get out before you get in. Because can IP be transferred if you want to exit without restriction? What are the limitations on it? These are some of the things that you should be thinking about. And of course, finally, get a third-party independent valuation of the IP, right? Do not take the word of the target on this. Right? Get your own independent valuation done. It's very important. I'll give you an example. One of the deals where I was working on, the investor did not want to get a valuation because they believed they understood what they were buying, they understood all the assets and what they were worth. Now the target company represented they have a lot of IP, which factored into the deal price, right? Now months later, we're doing due diligence and turns out none of the IP that the target claimed they had was actually secured. So now the term sheet was already signed, so it caused a lot of hiccups and delay in renegotiating the price. So very important not to take the word of either side and do your own analysis. Now let's look at it from the other side, right? If you are the innovator who has the IP and who is looking to, make a deal with an investor, what should you be looking at? Obviously, protect your IP before you pitch it, right? Goes without saying, you can make a deal of something that you don't own, right? So get your house in order, file those patent applications, those trademark applications, have the NDAs in place, have all the, record your inventions, your lab notebooks, your testing data. They should all be time-stamped and ready to go. Do not rush to disclose your sensitive data. This is something that I see often, that innovators rush to do a demo of their product. That or, they want to share their technology or innovation. This is when the risk of IP peaks. This is like one of the times when all the breaches happen and all kinds of, litigation comes out of it. So be very careful. And yes, you should have good deal hygiene. Again, as we talked, you should have all the correct assignments, IP assignments properly done from the contractors or the employees or the independent, consultants that you hired. Have a ownership register or an IP inventory to across all of your companies, right? If you have like a group of companies, especially this becomes more important as who owns what. That should be clearly, tracked. Now, these all may seem like small administrative steps, but they prevent major hiccups down the road. Again, one of the deals that I was handling, where an IP holding company, right, was stalled in almost like $100 million deal. And the stalling happened because of a gap in the chain of title, because of a foreign subsidiary that they just didn't catch in time. So these are, again, simple steps, but they prevent a lot of headaches down the road. And again, just like the investor, as an innovator, you also want to make sure you get the protections that you need from your agreement, right? And clearly define who owns jointly developed IP. And joint doesn't mean equal. So spell out who owns how much and who gets to use what. Okay? And be explicit about the territory and field of use limitations. Right? Limit where and how your technology is going to be used so it doesn't get exploited beyond what you intended it. Right? For example, a US innovator company license could say, use the technology only in India. So the Indian company will not be able to export that product into US or even to Europe, for example. So think through all these kind of situations. Now, make sure the license is not too broad or too long, right? Then you're giving up the leverage of future commercialization opportunities. And think ahead. We talked about this in the earlier panel. Think about how you would enforce your IP rights. You know, what jurisdiction do you want? Do you want India? Do you want US? You know, what kind of law? And who should pay for it if there is enforcement proceeding? All these things should be, you know, thought out and included in the contract upfront so there is no issue later on. And yes, of course, background check your investor. Okay? It's not just enough that they're bringing you money. You want to make sure that the investor is someone who has a track record of respecting IP. They're not acquiring IP to copy it or to just shelve it. So capital is important, but so is alignment with your values. So as we try to balance both sides, investor and innovator, when you're doing the deal, something to keep in mind, right? The core challenge in any cross-border deal, whether it's US, India, or some other countries, the core challenge is building trust and alignment. Not so much, you know, both sides want to scale the innovation, but they view the risks differently. So what both sides ultimately want is clarity on, you know, your rights and obligations, continuity on collaboration, confidence that your interests are going to be protected. Typically where the tension arises is between transparency. The investors usually will want more transparency because they want oversight. Whereas the innovator wants to maintain their autonomy, and they want to protect their know-how. Okay? So many disputes often arise because of poor drafting of contracts. I cannot tell you, almost every single case that I litigate comes out of a contract that is not properly drafted. You know, it is an investment that you as a company should be willing to make, because whatever money you're spending in getting properly drafted contracts now will save you a ton of money later on when either the section is not clear, or a lot of times the sections are not even there. Right? So these are some things to keep in mind. So what are some practical takeaways? Right? Remember that in most cross-border deals, IP confusion or IP issues are the #1 reason for the deal getting delayed or getting repriced. Right? So you want to pay attention to the IP. Right? Have the right mindset. You know, IP diligence is a collaborative effort. It's not supposed to be adversarial. Don't make it adversarial, and don't treat it like an interrogation. You know, the goal ultimately is to get value clarity, right? To understand how much is the IP at issue really worth, and how does it fit into the business strategy of both companies. Plan early, right? Start your diligence before the term sheet is locked in. You know, waiting too long will again, you know, restrict your ability to structure the deal or, you know, negotiate for protections. And build future-proof contracts. What do I mean by that? Anticipate changes to the extent you can. Changes in law, changes in business priorities, changes in market dynamics, and try to address those, all of the ifs and buts scenarios in the contracts. And don't overlook cultural alignment, right? US and India deal teams differ in the way they do documentation, in their risk tolerance, in their communication styles. So trying to align those early on and bridge those would avoid some friction, unnecessary friction later on. And finally, this kind of thorough diligence and documentation takes a lot of effort, energy, time. But after all, you're dealing with your crown jewels, as I said, so you want to make sure you budget for it accordingly. So with that, thank you. And happy if anyone has any questions. Yes.
Hi, my name is Radheja. I'm a US-India lawyer as well. Couple of things you mentioned within your talk. One is regarding joint IP, so this may be a little longer question. So I typically work with founders, and one of the basic recommendations that we always give to our clients is, one, have a founder agreement, and two, assign all of your IP to the company, just to avoid issues with disputes regarding the IP, and also any founder exiting and taking the IP and starting a new venture. Mm-hmm. So you mentioned joint IP as one of the ways. Don't you think that that would actually lead to fragmentization of the IP, and then when acquirers or any other interested party comes in, they would look at that specific IP as an issue when it comes to the acquisition, because it's so fragmented between two parties. So what's your recommendation here? Do you recommend that the innovator should file the IP, or whether there should be a joint IP, or the recommended route is actually what we have always been advising, is that company should own the IP, all assets, all IP assigned, whether by employees, contractors, founders, and even anything that was made prior to the company being incorporated. We usually always have it assigned to the company. So what are your thoughts on this?
Sure, that's a good question. So, when we're talking about joint ventures or joint partnerships, there are two kinds of IP. One is what I call background IP that exists before the joint partnership. And this other is the foreground IP that comes after the partnership. Let's say, both companies are working together on R&D and something new comes out of it, right? So when we're talking about joint IP, or, the new IP, that's the IP, the foreground IP. Now, it depends on who should own it, really depends on the specific situation of the deal. You can have a lot of times, I've seen it in all kinds of, there's no one size fits all approach. So depending on what the priorities are and what the goals are, you will figure out, and who has leverage, right? If Company A owns all of the background IP, and Company B is now providing some help to come up with an improvement, maybe they'll be listed as an inventor, but the ownership still stays with Company A, right? So these are like different aspects. You just have to think it through, because there is no uniform rule that says you should always own it to a company. I mean, in general, an inventor or a founder should not have IP in their name. Well, for obvious reasons, as you said, right? If you're doing a deal, you're not acquiring the individual, you're acquiring the company, so company has to have the IP. It even, comes up in bankruptcy situations, right? If the asset did not even belong to the company, so now that's, it creates additional issues. So yes, IP should typically be owned by the company, but which company owns IP coming out of joint collaboration is, a complicated analysis that is based on the facts of the situation. Okay, well, thank you very much.
Thank you, Ms. Chinta, for enlightening us with how we can safeguard our intellectual property in international collaborations. Our next speaker is Dr. Kabir Duggal, Senior International Arbitration Advisor at Arnold and Porter. He'll be speaking on the great Indian arbitration turn from reluctance to reform. Dr. Duggal is a globally recognized thought leader in international arbitration, and we're delighted to have him with us today.
Good afternoon. Wow, wasn't expecting that, but it's always nice to hear it. I know we're running woefully behind schedule, and I'm standing in the way of butter paneer or butter chicken. Do you want me to compress the slides, Arvinder? I can do that. Would that be helpful? I'm hearing yes. People have their priorities straight. I'll do this more quickly, so just in the interest of time, we're going to be talking about arbitration here, and I will thumb through this. If anybody wants the slide, Arvinder, Priyanka will get it to you. There are GIFs, so that's always fun. I'm going to start off by insulting your intelligence. What is arbitration? Arbitration can avoid everything we were talking in the prior session. You can forget it. What venue, what place, just put in your contract. We're not going to go to courts. We're going to go to arbitration. And courts will respect that, because if you subscribe to the notion adults can make life choices that will be respected, that's arbitration. I'm going to agree with you, let's not go to a court, and the court is happy, the judge is happy, less on my docket. You want to solve your problem in front of people outside my system, more power to you. That's arbitration. Now, we're talking of a special form of arbitration, investor state. And it's premised on a simple notion: if you have problems, right? As a foreign investor, that's the idea here. Investor state arbitration is arbitration when there is a foreign investor having a problem with the country. Let that sink in for a minute. Your respondent is always going to be a sovereign. The Republic of India, the United States of America, right? It's a country that is the respondent. How do you get access to this form of arbitration? You get access through treaties signed by countries, right? So Trump, Modi get together, sign a treaty. It gives right to Indian companies in the US, to American companies in India, that if there is a problem by the Indian or the US government, you understand the situation, you can sue the country directly for a lot of money. Millions or billions of dollars. So there's a lot at stake here. That's the point I want to make. Just note, a big award against India is a big award against the Indian people. The taxpayers are going to pay it, right? And that's what you want to think about. Now, I'll do this relatively quickly. What is India's experience with investor state arbitration? It is a Bollywood story, right? Now, I'm going to say Bollywood because that's what I'm familiar with. Tollywood, any of the regional film industries, it would apply equally. We're going to have a happy face. We're then going to have a sad face. We like drama. And then there's going to be a reconciliation phase. Take any Indian movie. This is the plot. Okay? So let's look at the happy phase. It's relatively new. Remember, India used to be a closed economy. It opened up in the 1990s. And when India decides to do something, we do it with a bang. Right? Till 1991, no treaties, We start the process of signing these treaties in 1994. Obviously, we started with the UK. There is some Stockholm relationship with the UK. And then India goes ahead and signs 18 of these treaties. You remember the judge talking of the investment chapters. We sign 18 of those. Now, just to put this in perspective, the US has about 40. In Hindi, 40. India was more than double. Not exactly sure why. There is an explanation in 10 seconds, but everything was going good for India. The story will change in a minute, but everything was going well. Now, just on these treaty negotiations, let's look at Pakistan's example. Why are we looking at Pakistan? Well, we're talking about India, so it's always fun. But there's a story. While India was a closed economy, the first investment treaty was signed by Pakistan. They took a different approach to India. In 1959, they signed the first treaty between Pakistan and West Germany. Now, this is the former Attorney General of Pakistan. When they get sued for the first time, the Attorney General goes to Google and puts in, what's an investment treaty? What's the forum to solve these? It's a forum within the World Bank. What's this forum? Couldn't find any answers. He tries to look at the negotiating history for treaties, couldn't find anything. And he comes to this great conclusion that we had foreign delegations coming to Pakistan. You needed to do something. Let's sign these treaties. That's how these treaties were signed. India has about 90 of them. Okay? It was a time bomb waiting to burst. And that's going to be phase 2. The drama. Okay? Everything was happy in the 90s. This is probably the most embarrassing GIF ever. Okay, nothing happened till a very small dispute brings the potential of these treaties to the Indian administration's attention. Now, I'm going to simplify this, but you're going to have a dispute between a state entity and an Australian company. Now, this is very standard in India. I was going to make a big speech about how Indian courts are famous for being slow, but the judge gave us the example a little time ago about the US, so India in comparison looks similar. But the dispute starts in 1999 till 2010. We are waiting to enforce the judgment. Okay? And so the Australian company will sue India under a treaty. Okay? And just note, the amount here isn't big. Today, if there's a $4 million Australian dollar award, people would do cartwheels. The case against Russia that's pending for enforcement is, I think now it's $111 billion. That's Aryabhat's photo there. He is one of the most famous mathematicians who discovered zero. That's one of our big contributions. $111 billion, I don't know how many zeros are on it. Okay? There's that much money at stake. This is peanuts. This is chump change. Okay? Now, what's going to happen in this case? Just note, 11 years in India is not outrageous. But when the matter goes to the arbitral tribunal looks at it and says, this is outrageous. India has violated its treaty obligations, and India, the Republic, has to pay this Australian company money, and the Indian administration suddenly gets shocked. Oh my God, these treaties actually have legal effect. There's going to be another case involving space, and I heard some mention of this, but this is a company gets a contract. The contract, it was Indian Americans, the business, but Americans, just not. Indian Americans, from a structuring perspective, they were US companies. Their business was they were going to show cricket and movies, the two things that make Indians happiest. The third thing is weddings. Okay, at least some Indians found that funny. It's cricket, Bollywood, and shadi. Right? The three things that make us happiest. Right? So that's what their business was. They were going to do this through a satellite, a very valuable satellite, the S-band. The Indian Army tells us we kind of need this band for our army. And so they will terminate the contract. The company will sue India, and India's defense, just note, there are going to be multiple actions in multiple forums. Right? So again, talk about the Indian government getting really upset. The army is implicated. Big stakes here. The arbitral tribunal rejects India's defenses. India tries to tell us we are doing this for security, and the tribunal didn't care. Security. Okay? So India is found liable. This award is today a little over $1 billion enforcement action pending around the world. This was the case where in Canada, one of the Air India planes was attached. If you remember this from a few years ago, Arvinder, you may know this if you were following Canadian news. They had attached an Air India plane. It was to enforce this award. So this really got the Indian government upset. And that takes us to phase 3. In phase 3, India decides we're going to rethink our investment policy. They start the negotiations. Well, they started it in 2011. It took 2015 for a draft to come out. It is India. It took some time, but a draft was given. Comments were sought from the world, which there was some consultative process. At the end, India issues a final model that had no correlation to the draft. Something happened between the draft and the final model. We are not exactly clear. But India scaled back a lot of very forward-thinking ideas. We believe there must have been pressure on the government. But, as the judge will tell you from the negotiations of these treaties, how the sausage is made is often there's a lot of things happening that are not visible to the naked eye. Now, what is India's big solution? India's big solution is we will allow investment treaties, but you have to go to Indian courts first for 5 years. Now, this had a lot of non-Indians very stressed out. 5 years, oh my God, too long. This seems to have become a norm. 5 years today seems to be a standard pattern that a lot of countries are adopting. India is embracing arbitration. One of the sponsors for today's event is the India International Arbitration Center. We heard Justice Gupta, right, the chairperson of this body, and the Act of Parliament has declared this institution to be of national importance. Right? India wants to portray to the rest of the world, we are a responsible country, we take business seriously, come do business with us. So we're at a stage where the scene for arbitration, the scene for the rule of law is looking promising. It's still a nascent moment, so let's see how this plays out. But with that, this is funny. I may have gone longer than 10 minutes, but I'm lower than the time that I was allocated, so yay! With that, let me stop here. If you ask a question, you can ask a question. You are butter chicken and butter paneer. Just remember that. Good. Enjoy lunch, I guess. Not yet, okay.
Thank you, Dr. Duggal. Thank you so much.